When someone dies in Florida, their assets do not automatically transfer just because the family knows who should receive them. Sometimes the court has to step in. That court process is called probate. Probate is the legal process for identifying a deceased person's assets, handling valid debts, and transferring what remains to the people legally entitled to receive it. In Florida, the main probate rules are found in Chapter 733 of the Florida statutes. A common misconception is that a will avoids probate. It does not. A will tells the court who the person wanted to inherit and who should be in charge of the estate. But the will usually must be admitted to probate before those instructions can be carried out. If there is no will, Florida's intestacy rules decide who inherits. Not everything a person owns goes through probate. Probate usually applies to assets titled only in the deceased person's individual name, with no surviving joint owner and no beneficiary designation. That could include a bank account, vehicle, or real estate titled solely in that person's name. Other assets may pass outside probate, including life insurance with a named beneficiary, retirement accounts with beneficiary designations, payable on death accounts, jointly owned property with rights of survivorship, and assets held in a properly funded trust. Florida generally has two main probate tracks. The first is formal administration, the full probate process under Chapter 733. The court appoints a personal representative with authority to gather assets, protect estate property, publish and serve notice to creditors under Section 733.2121, pay valid claims, and distribute the balance. Formal administration is usually used when the estate is larger, more complex, contested, or does not qualify for a simpler procedure. The second track is summary administration, under Section 335.201. This is a shorter process for qualifying estates. Instead of appointing a personal representative, the court can enter an order distributing the assets. Currently, summary administration is available when the Florida estate, subject to administration, minus property exempt from creditor claims, does not exceed $75,000, or when the person has been dead for more than 2 years. That dollar threshold is changing. Under Florida's 2026 estates legislation, effective July 1, 2026, the summary administration threshold increases to $150,000. The 2-year alternative remains. Florida also has a very limited procedure called disposition without administration, under Section 335.301, generally for certain final expenses and very small amounts of property. Probate is not a punishment. It is a court-supervised transfer process.